whatever happens to Aereo, the industry from now on is going to be forced to move forward and innovate.
The Supreme Court will soon reach its decision on the much-publicized Aereo case, a case many believe will have a profound effect on the way we watch television. As Aereo CEO Chet Kanojia explains, it all started by rethinking a basic staple of 20th century analog broadcast technology, the antenna.
This is actually a micro antenna. It's capable of tuning to any channel that you instruct it to tune to. Along with that, we built in a DVR in the cloud so that you as a consumer can say, I would like to watch ABC. You wake up your antenna by sending it an impulse, and it starts up your DVR, so you can pause, rewind, save the programming for later if you want to. And it's simple.
But what seemed simple to Aereo smacked of copyright infringement to the major broadcasters and their allies. In the Copyright Act of 1976, Congress mandated that cable companies must get broadcasters' permission before retransmitting their programs to the public. Broadcasters feel Aereo is retransmitting copyrighted work to paying customers and should be subject to the same retransmission fees cable and satellite companies currently pay. Aereo is arguing that it is simply a technology company renting individual antennas and cloud storage accounts to individual users, and therefore is not engaged in the public performance of copyrighted works that are subject to these fees.
Nobody disputes the fact that you can have an antenna. Nobody disputes you can have an antenna on your roof versus your TV set versus the base. It doesn't matter. There's no rule that says how long the wire should be that connects your device to your antenna. It's established that consumers can make recordings in their house. Sony and everybody has got a DVR, the cable company leases you one. So what's different about this? The wire is just longer. So we expected some controversy, but we also hoped that that basic simple logic would sort of sit with people and they would see the opportunity as opposed to resorting to the first line of offense, which is lawsuits. But unfortunately, we were disappointed.
After a few circuit court skirmishes, the Supreme Court took up the case.
There is no question that this is a gimmick.
Steve Efros is a television industry consultant and former lobbyist for the cable industry.
The consumer can decide, I want to record, Game of Thrones, or I want to record NBC, or whatever. The cable operator is required to have the licenses and contracts to send that material down to the consumer in the first place, including broadcast television. What Aereo is saying is, because of technical terms in the copyright law, this little thumbnail antenna means that the subscriber has already received the programming, and then we record it, and then we distribute it to them, but we don't have to pay the broadcasters because it's free over-the-air television, so we don't have to pay for it because it's not a performance at all. Well, the problem with that logic is, of course, you didn't pay for it the first time. It's true that the second time it's not a performance for profit that you have to pay for. But what about the first time?
I don't know that this is a loophole so much as just an indication of how complex copyright law has become.
James Grimmelman is a professor of law at the University of Maryland and co-author of an amicus brief arguing in favor of Aereo.
Douglas Coupland wonderfully called the computer the every animal machine because it's capable of acting like anything. And that's how the internet works. It can act like a cable system. It can act like a storage device. It's TV, it's radio, it's telephone, it's telegram, it's telegraph, it's everything. That means that a regulatory system that treats these different media differently is going to throw up its hands in confusion when it hits the internet, because suddenly your old distinction between phone calls and television collapses.
April's oral arguments gave little indication of which way the justices will rule. If the Supreme Court comes down against Aereo, both Kanojia and Aereo's high-profile backer, media mogul Barry Diller, have stated it will likely be the end of the company. Win or lose, this case underlines just how antiquated and unresponsive our regulatory and copyright framework has become in an increasingly digital age.
In the long term, the broadcasters and Aereo are both going away. Delivering video over the air indiscriminately like this is a model that you only use when you don't have the internet.
Frankly, I think most broadcasters should be taken off the air. I think their frequencies should be taken back. The government should use it for Wi-Fi and lots of other stuff that would be much more beneficial for the public than what we've got today. And if Mr. Kanojia and Mr. Diller want to argue the case with us that there's a much better use for broadcast spectrum, I agree with them. And if they want to argue that the term free TV is a fraud, I agree with them again. But playing this type of game is just a game.
I'm there to try to be part of the change and see if there is something I can do to contribute for a better experience. I didn't cause this change, right? The change has been brewing since the internet started moving bits around.